just kind of give you an overview of what we're going to do tonight. So first we're going to go, John's going to go through and just talk about some different things about contracts, some different state statutes, requirements. He's going to get into some nitty gritty with you. And then we're going to do a few things. So I'm Stephanie Black, for the people that don't know me. I am co-founder of Credit Butterfly, which is credit repair software. Kim Moses is my partner, and she is the other co-founder of Credit Butterfly. And what we're going to do today is we're going to have John go through the contracts. He's going to answer any questions you have surrounding the state contracts, in your own state. He's going to go through a lot of particulars for specific states that, have some way tighter requirements than just basic CROA. Are you going to touch on CROA too, John? A little bit, just CROA?
Probably a little.
Huh?
Probably a little bit. Yeah.
Yeah, probably a little. So there we go. We'll touch on, CROA, and then we will do a demo of Credit Butterfly, and we're going to show you how we've integrated these compliant agreements inside of Credit Butterfly. At the end. And then we're also, if you guys stay till the end, you're also going to get what is it, Kimberly? You're going to get all of the state statutes.
Yeah, so we have a spreadsheet like with all the links to all the state statutes and as well as like exactly what each state requires so that if you have, you work in several states and you need to kind of draft your own contract, you'll know what is required so that you can be compliant. But John will talk about that.
We do not recommend that you draft your own.
No, but it has all the stuff in there just so that just to make sure that you have the ones that you have now, you can kind of look at that and see, kind of do your own risk analysis. But I'll let John do his presentation and he can share with you the risks of not having a compliant contract. Okay.
Yep.
That's a handy little guide anyway, so.
Yeah, so everybody is going to get that. If you're on the call today, you're going to get that guide. Okay, just stay to the end and we will pop it into the chat for you at the end.
No, I'm not going to pop it into the
not?
chat. I'm going to email it out tomorrow because I want to verify all the links to make sure.
She'll update the links then.
Double check.
You tomorrow.
Okay.
Perfect. All right, so let's get into the slides. Let me just cue them up here.
So while you're doing that, I will tell everybody this is not legal advice. I do have a degree in law, but I'm not an attorney. I didn't take the bar. I didn't want to take the bar. I just wanted to write contracts. So it's always good to do your own due diligence, do your own research. But what we'll talk about is, from my experience in drafting these contracts for quite a long time, they do get updated. California updates theirs pretty regularly. Other states will, do theirs periodically. So, Washington, I think, just did theirs 1 or 2 years ago. So, you got to make sure that you're staying on top of that. And as we go through it, we'll talk about some states, some have bonding requirements, licensing requirements, or both, right? And some don't have any. So, they're not all the same. So it's very important to understand that, especially in the state that you're working in, being very familiar with your statute.
Okay, and I think that was that slide, right, John?
Yep. Yes, this presentation is provided for informational purposes only and does not constitute legal advice. Be aware that statutes may change over time, and we recommend conducting thorough research and verifying the current statutes independently. Very good.
Okay.
So there's a particular credit repair software that I won't name names, but everybody is aware of it. They got sued by the CFPB also. They provide a templated agreement in their software, which is not a compliant agreement. It's not even CROA compliant. It has nothing in it. There's nothing there. There's no state language. It even says in their, where they put their information that you need to research your state laws and things like that. So if you have, if you've been using another software, make sure that you're making sure that that software has, or that contract has the state required language in it. All the contracts have to have CROA components in there, but most of the states also have their own requirements. They either have requirements for their contract or their state disclosure form, which is also called a client information statement, or they have requirements for both. So make sure that you understand that.
I'm trying to move your slide.
That's okay.
Okay, so.
Wrong way.
Yeah.
Okay, so I touched a little bit earlier. So bond requirements, licensing, obligations, and then terms of your agreement. So these are things that will be in the statute. Like California, I think, is a $100,000 bond. They also have a license requirement, and in order to be a credit repair organization in California, you also have to fill out a application form to be a credit repair organization, right? Oregon has the same thing. Ohio has the same thing. Their requirements are all a little bit different. None of their contract language is the same as far as their specific contract language that's required. Also, term of the agreement restrictions, right? California is a 6-month contract. State of Ohio is 2 months, right? So you have to renew that agreement every 2 months. And you can't just have an agreement that says it'll renew itself every 2 months. You want the client to, sign another agreement so that they know that they've signed for another 2 months. Because if you continue to allow us to have an agreement that has that, renewal, you could get someone that's paying for, several months worth of credit repair and didn't realize that it was being renewed, and then you get into a legal issue. Always make sure that at the term of the agreement, you have them sign a new agreement for additional term that you previously had in your prior agreement.
So when you say things like the language in the contracts, on state required, like they actually require like very specific verbiage, right?
Yes.
For different
Yes.
states. Like CROA says one thing, but then the state statutes will come in and want some, like, it'll literally have like a line here. You have to have this line exactly as this is written.
Right. There's stuff that's exact. So CROA requires 2 cancellation notices. Their cancellation notices are very specific in how it's, how it's written. The states that require that, which is all of them, also have their own version, right? So you'll have a state-specific language that goes in there, and it has to do. It's really strange that they don't all just have the same one. It doesn't make any sense. I don't know why they don't just all make it over, the same as CROA, but states can have more strict language than the federal government, but they cannot have less strict language. So that's why you also have some states that have, instead of a 3-day, the 3-day period where, client can sign your agreement and then 3 days later cancel it, right? Your cancellation period. Some states are 5. California is 5 days, right? So in their cancellation notice is the 5-day term. It also will talk about how, if it's working days, if it's just days, so business days. So there's different ways they say it in different states, right? So you have to be very conscientious about that, because if you have a 5-day working period, then your weekends and holidays don't count. But if it's just 5 days, then it doesn't matter if they're weekend and holidays because it says 5 days. So be very conscientious about what your cancellation period is, right? So CROA, as far as their requirements are pretty easy to understand, and pretty straightforward. But sometimes they conflict with the state, right? But like I just said about the 3 or 5 day cancellation period. So make sure that if you're drafting your own agreement, which is perfectly fine for you to do, make sure that your state language is what the state wants it to say. Okay. They also have things like they're cancel. So at the signature line, you have to have a right to cancel at your signature line or near your signature line, and everybody's says it differently, right? So, for instance, if you go to Illinois, that says, something like the buyer may cancel a contract anytime before midnight of the third day, right? And California is going to say, let's find California real quick here. There says the consumer may cancel the contract at any time before midnight of the 5th working day after you sign it, right? So there's very different, differences in the way it's written. So you've got to make sure that your contracts have the language the way they have set it out in their statute. And it's it says it right in the statute. It has to say it this way. So you can't miss it.
Yeah, and there's majorly specific things, like especially for some states, like let's talk a little bit too about like Oregon, what is it? Oregon, South Carolina, and what was the other?
Yeah, so Oregon, South Carolina, and Kansas have restrictions on the amount of fees you can charge or what the fees can be, right? So like Oregon, for instance, they have a $50 initial consultation fee, and then they have a $50 a month fee, right, for doing the credit repair. They also have I can't remember what it's called exactly right now, but it's like a $50 fee if the client consults with you, but they don't sign up for an agreement, right? So you can still charge them a $50 fee if they don't sign up, but you can't charge them that if they do sign up, right? So it's only if they don't sign up that you've consulted with them and educated them that you're $50. Those 3 states are also called debt settlement agreements, or not debt settlement. What the heck is the word? Give me 1 second. I can't remember the exact term.
Debt management.
Debt management. Thank you, Shar. They're debt management agreements. They're not credit repair agreements. And so they have very odd requirements in their statute and how they administer that. And one of them, Shar, correct me if I'm wrong, does Oregon have an education requirement, or is it Kansas that has the education requirement? Or South Carolina? Maybe it was South Carolina. What was that?
It's not Oregon.
Okay, so I think it's South Carolina. You actually have to get certified in debt management, and you have to I think before a client even signs an agreement, you have to write a budget for them and everything. I mean, it's a whole weird thing that you have to do prior to even getting into an agreement with them. And then, so here's the question: is how does that TSR work with that, right? I mean, it's kind of a odd thing.
Yeah, it really is. So, and then on a lot of them, like how many of the states do you actually have to be licensed in? Like where you have to get an actual license?
Let's see. The last time I checked, there's 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13. Excuse me. 14, 15, 16, 17, 18, 19, 20, 22, about 23.
Okay. Because
it's almost half.
A lot of states, like you have to get bonded in some states, right? There's just a lot of different requirements. Some states you need a bond. Some states you need an actual license. Some states you need a debt management license. So it's important that you know all of these things, and what the thing that we're giving you gives you all of this criteria too, so that you know what's, required really in your state. But these are so complicated. I didn't realize like how complicated a credit repair contract really is in order to protect yourself and your business. So getting it right is really important for
It
you.
is important.
The other cool thing that John includes in all of his contracts is the TCPA language, right? Can you just explain what that is and why that's
Yes.
so that
Yeah, so TCPA is the was it Telephone Privacy Act or something like that. So it talks about
Telephone Consumer Protection Act.
There you go. Yeah. When you're communicating with your client, right, you're either going to email, you're going to text, you're going to call. And what it is it's language in the agreement that says that the client is agreeing to allow you to communicate with them with the phone number they provide you, the email they provide you, that you can leave a message for them and things like that. It's very important to have that in your agreement, and you should also have that in your on your website. If you have a website, in the footer where you have a privacy policy, you should include that in your privacy policy. You can cut it right out of the agreement and put it right in the privacy policy as well. So California, for instance, has a stricter TCPA requirement than the other typical states do, where some states allow you to record calls without their permission. California, you still have to get permission to record your phone calls with your clients. You can't just automatically do it. Okay. So, you got to make sure that you understand what's required in your state and make sure that you're, in compliance with that as well.
Okay. Do you have anything else you want to add to that right now, John? Any just like specific things that you normally talk about?
Not now, but I'm sure something will come because there's always something popping in my head as I'm thinking. So something may come up, but it's just the thing I want to make sure that everybody understands is that it's very important to make sure you understand your state statute. There are about 12 states that don't have specific state requirements. They don't have any contract language requirements. They don't have any bonding or licensing. So CROA is the only thing that you have to make sure that you're compliant with in your agreement. But the rest of them have either your contract and or your disclosure that has to be very specific in what they want in it.
Which states don't have requirements? Like
that would be
in those states.
It'd be Alabama and Alaska.
Alabama.
Yep. Alabama and Alaska, Montana, New Jersey, New Mexico, North Dakota, Rhode Island, South Dakota, Vermont, and Wyoming.
Vermont and Wyoming. Okay, cool.
Yeah.
So now everybody that's on the call, who has a specific question for John on your state? If there's anything you want to know, maybe just about specifically your state that he might be able to answer for you, I think he's more than happy to do that.
Yeah, and if you think of something later, just put it in the chat there, and if I see it, I'll make sure I respond to it.
I have more of a general question, not state specific. Are we ready for that, or should I wait?
No, go ahead.
Sure. No, any questions? Go right ahead.
Okay. Yeah, so like my main business isn't actually credit repair, it's like financial coaching. So it's like credit repair is just like a piece of it. Do I still need to have compliance with all this stuff?
Yes. If you're doing credit repair, you still have to have a credit repair contract and the licensing and bonding requirements that are in your state. It doesn't matter what you call it. You can call it, education. You can call it consulting. It doesn't matter. If it's credit repair or closely related to credit repair, yes, they consider it credit repair.
So even if it's just, let's say it's just debt payoff, right? Versus like actually like disputing or, other things like that.
Well, that's a different.
What's that? Where's that line at?
Yeah. So debt. So that's like doing like not debt settlement as far as like, paying someone's debts down or whatever. That's different. That's totally a different regulated industry as well too. But it just depends. If it looks like credit repair, then you need to have a credit repair agreement and follow the credit repair statutes.
Cool.
So
Thanks.
what do you actually do, Joel? What kind of services do you actually provide?
Well, I pretty much do like expense management, budgeting, and a lot like infinite banking stuff. So debt payoff via infinite banking. Working with Taeyon quite a bit with that. So yeah, kind of similar to what he does.
Oh, okay. So do you ever send any disputes out or anything like that for clients?
I mean, I can and I would, but it's kind of not like the main thing that I'm trying to do, you know what I mean? So
So yeah, if you do anything that's like actually credit repair, yeah, you're gonna have some type of
Yes.
So can I help
What
answer
state are
some
you
of
in?
that, guys?
what?
yeah, for sure.
What was that?
I was just going to ask if I can chime in, John.
Yeah.
My understanding of credit repair is anything that you're doing to help increase a client's credit score. So a lot of people get away with this. I'm doing consulting or I'm doing financial education, but really in reality, they're educating them how to go and pay off debt or pay down credit cards or how to call a company and settle. Maybe they're getting on the phone and helping them settle, which is also against the law unless you have a settlement license in a lot of states. Idaho and Oregon, I cannot help settle debt. Then if you're doing anything with disputing or contacting creditors or contacting the bureaus or the collection agencies on behalf of the consumer, that is under the umbrella of credit repair and you have to follow your state guidelines for it.
Understood.
Yes.
Makes sense.
Yep. What state are you in, Joel?
Arizona?
Arizona? Okay.
Okay, and then Kelly has a question. She says she's in Ohio and she's licensed and bonded. She wanted to know if she can charge a $50 fee if they don't sign up, but she did an analysis. Is there a specific agreement for that? Or is
Yeah,
that
I wouldn't recommend it because it's part of the credit repair process. And so it should be included in your initial, when you sign up the person and you do their initial analysis and things like that. It should be. So what I recommend clients do is do a very
consultation, but they don't
Right.
actually sign up. Can she charge a
No.
consultation fee?
No, it's part of the credit repair process, right? So you can't, unless the state has a specific thing like Oregon does, or yeah, Oregon, I think it is. It says that you can charge that $50 fee if they don't sign up, but that is a very gray area that I would be very careful about, especially in Ohio, since you have to go through a whole application process. You have to disclose that to the state when you apply too. So, I mean, if you apply and you include that as part of your business, strategy, then they approve it, then great. But I would make sure that they approve it before you do it, because to my knowledge, it is not a legal thing, because if you are doing a consultation, it's part of the credit repair process. It's considered credit repair. And so typically what someone will do, most credit repair organizations, they would say, they'll do a brief consultation where, some will get them to sign up for a credit report for free to get a credit report so they can review it and just kind of hit some high points, brief consultation. And then they don't sign up, great. They don't have to deal with it anymore. Or they sign them up and then they do a more comprehensive consultation and more in depth, and et cetera, et cetera. And in your agreement, it talks about, what the fee is for that, right? CROA requires you to have a contract if you charge a fee, right? So even CROA doesn't allow that, right? So
Right.
I mean,
Yeah, Tim Williams is asking, would it be better to say application fee?
Doesn't matter what you call it.
Like a duck.
Doesn't matter what you call it. You can put it in a contract for credit repair as an application fee if you want to, but it's still part of the credit repair process. You're charging them a fee. It's got to be accounted for. All of the statutes say you have to, include in your agreement all of the fees that you charge.
And CROA says basically that you can't charge up front for anything until you've
Right.
completed it. So could you have an application fee in your agreement if you wanted to?
No,
And
I wouldn't call it an application fee.
because I just don't think that's,
No, and you shouldn't charge for, I wouldn't recommend you even charge anybody until after the 3 to 5 day wait period is, depending on which state you're in either. Because CROA has some language in there that some people interpret as do not, you cannot charge anybody for the waiting period. So not only that, do not do any work for the client during that waiting period is what, CROA implies. So when you do, people call it a setup fee, an application fee. Don't call it that. Call it a consultation, and like a
for me,
consultation
I
fee.
I do a credit evaluation.
There you go, something like that.
Full
Yes.
credit evaluation and action plan. So it's an actual thing. Like I do the full evaluation, I send them an actual written action plan so that they have something. They have like a tangible thing that I actually did, and then I charge the fee.
Right.
And that's
Right. And your first initial fee is typically higher than your monthly fee. So your first initial consultation should also include your first round of dispute letters because you're charging more, right? So, and then you have the monthly fee, which I don't call it a monthly fee, I call it per dispute fee, because you have to be very careful that you don't call it a monthly fee and you don't have automatic payments set up at 30-day periods, because if you charge somebody and have an automatic payment go out before the service has been rendered, you're in violation of the law because you cannot charge before services are rendered.
Yeah,
So I
think that's
about that.
Super important point, because a lot of people do charge like the every 30 days, but charging per round is a much better way of doing it so that you're not afoul of the law.
Yes. Now, some people will charge 30 days in arrears so that they're charging their first monthly round 60 days later, and then 30 days after that, so that it stays ahead of the monthly fee, right? So just make sure, however you set it up, you're not putting yourself in a situation where you're charging before the service is rendered. There's no exception to that. They don't care if you set it up and forgot. The money comes out of their bank account, you haven't done the service, then you're in violation. They're not gonna, there's no ifs, ands, or buts about it.
Yeah, that is important. Okay, so Brenda Epkins has asked, what if people are interested in a DIY service? Can you charge for an audit/analysis? And she's in Florida.
So DIY means DIY. It does not mean that you have any part in the process. So if you have a DIY program, it should be separate from anything that you do for the client, meaning that you can't have a chat with them, you can't do an analysis for them, you can't have a consultation with them, because once you talk to them, you're doing credit repair. They have to be able to do it themselves, because that's what it's called, right? I also do recommend having a contract for DIY clients, so it specifically tells them that it's a do-it-yourself. There's no guarantees, blah blah blah, all of that stuff spelled out, so that there's no misunderstandings, with how the program works and things like that.
So let's kind of talk this through a little bit. So what if you do have a DIY program, and say you have a group and they're all DIY, they're doing all their thing, you're posting stuff, telling them how to do things and what have you, and they want just a consultation with you. They want you to look at their credit report, kind of give them an action plan. How do you do that? How would you charge for that? Do you have to have a full credit repair contract to be able to do that for
Yes.
that, like one?
DIY has to be separate from your credit repair. You can if you have a group or something, you can post videos in your group that give people advice. It can't be a specific thing to a specific person, right? You can't do lives and then answer questions. I mean, you're doing credit repair in that case with your DIY clients, so it turns it into a credit repair client, right? So you got to be very careful with that. Um, DIY is, do it yourself.
Got it. Okay.
There, there was also Florida made me remember. Florida is a state that requires you to have a bond, and they also require you to have a trust account. They require you to have the funds from the client go straight into that trust account, and you don't collect it until after the term of the agreement is up.
Okay, and that when you do that, like a trust account, that would also make you pretty much TSR-ish compliant
Yes.
too by doing
Yes, it would be in Florida, yes.
Okay.
Yeah.
Melissa has a question. Hi, I'm in California and I also have my real estate license and I'm curious how CROA affects me and my business. Melissa, can you unmute yourself real quick? Do you do credit repair? You have your real estate license and you do credit repair? I don't know if she can unmute.
So I'm looking, because I can't remember off the top of my head, because I haven't memorized all of this. I don't think there's exceptions in CROA. So
she does. She does do that. She does do credit repair.
So if you do credit repair and you charge for it, CROA requires an agreement. In California, unless they have an exception in their statute, your requirement or your agreement will have to have state-specific language in it, and you also will have to go through the application process for your license, and you'll have to get a bond and state-specific agreement and all of that other stuff.
Yep. So I think it just affects her just the same as it would anybody else, right?
Right. Unless they have an exception in their thing, but California cannot override CROA. So if you charge for it, you still have to have an agreement. So it's kind of a circular kind of a, CROA says you charge for it, you better have an agreement. So you just might as well follow the whole, state statute and everything, because you're gonna have to have an agreement anyway.
Got it. All right. So Brittany has a question. If servicing clients outside of the state you operate in, do you need multiple contracts, also bond or any other compliance matters to ensure compliance in each state?
Yes.
Operations are in California.
Yes. So your California agreement will not work in Texas, Washington, Florida, Ohio. They all have their own language specifics. So, you can have a base agreement that has very similar language in it for like your miscellaneous provisions, your, force majeure, your severability language, your dispute resolution language. But then you have to make it specific for that state and also the state required language.
Okay. Tim Williams wants to know, do you need to have an agreement in place for DIY? I think you touched on that a few
Yeah, I wouldn't say you have to, but I'd say I recommend it. That way you have the terms, the client has an agreement that states what the terms of the DIY are, so that there's no misunderstandings, there's no guarantees, they're on their own. If they're using a software system that you're providing them that says that we're providing this to you for you to, do your own DIY, what is it that the client is, what's the business obligations, what's the client obligations, what's the cost, how long is it in effect, what happens if there's a dispute, all of these things are important. But there's nothing that says that you have to have an agreement for a DIY.
Yeah, because I think most people for DIY would be using like Credit Versio, stuff like that, right?
Yeah, and they probably have an agreement in
I
their
think they
software. I don't know.
have
Yeah.
something in there in
Yeah.
place, I would assume.
Hmm. Yeah. But if you have your own DIY processes and you have your own academy or something like that, it's smart, I think, to have an agreement.
Yeah. So Melissa also had another question. Do we have to wait 6 months to bill? And I'm gonna just kind of answer that real quick. It depends. You get the lawyer answer. It totally depends on whether you have to comply with CROA or the TSR. So join us next week because we're gonna do TSR. And we're going to answer all those questions because this is a long, super long, convoluted answer. There's no easy answer to
Yep.
that, the whole
Yep.
question. So,
Yeah, it's really, really, really important. I mean, you should be in compliance with TSR with your internal state clients, but any intrastate clients, it's very, 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 very important to understand your TSR requirements and make sure that you don't violate for your out-of-state clients.
yeah. Okay. So, and I think Belinda had a question I saw. I think it was about DIY. I think everybody's kind of interested. A lot of people are doing DIY now. So I think they're interested in just making sure they're being compliant with the DIY. And maybe to know if you do any type of services for that, consulting services for that, where they could get something drafted, for a fee from you. And yes, he absolutely has consulting services. And in fact, if you want to go and tell them like how much it is
Sure.
each contract and what your consulting services cost, I'm sure everybody's interested in that.
Yeah, so my consultation fee is $150, and that's, answer any of the questions you have, about the process, the agreements, the DIY, whatever you want to ask me. And then if you decide you want me to draft a, separate agreement for you, whether it's a DIY agreement or something else, the DIY agreements start around $250. Depends on how much information you want in the agreement, but it's about $250. A credit repair agreement is $595. And it doesn't go up or down. It's $595. But the $150 consultation fee is credited towards that agreement, whatever agreement you want me to draft. And Stephanie will talk about the fees for the software and things like that, and anybody on this call in using her software and things like that, I am discounting the consultation fee to $100. So
yeah, so what I'm going to show you how we've integrated the contract. So I know a lot of you were on here because I had posted some things too in my Facebook group about here's a way to get all of the contracts for free, basically. And that is through Credit Butterfly, which is the software. So we have worked with John and we actually integrated all of his compliant contracts for every single state into our software. So that comes with the software. We are in beta right now. We are signing up actual beta testers. So I'm going to show you how it works. Does everybody want to see that? Like how the agreements work inside the software? Is that okay with everybody if I give you a quick demo of that inside of Credit Butterfly? Okay, Clay says yes. Glenn says yes. All right, so we'll go ahead and do that. I'm just going to show you how that works.
And Timothy asked a question about whether you should mention compliance with TCPA. I think TCPA should be mentioned in your agreement because it talks about, the client is agreeing to that language in your contract, saying that they're giving you the permission to contact them by phone, email, leave voicemail, things like that. So I think it's very important to have in your agreement. And it's in all of the agreements I did for Stephanie.
Yeah. So it's cool. So I'm going to show you what we did with his agreements in Credit Butterfly. Because it's super cool. There's really no other software that has done this. So is everybody seeing my screen?
Yes.
All righty. All right, so let me just move this thing out of the way. The photos. Okay, so I'm just gonna go in, and when you go into Credit Butterfly, you can go in and you can add a lead. So we have a flow in here that works with the agreement. So you can just create, I'm gonna create a lead in here. So we'll just call it Mickey Mouse. Okay, so once we save that, so whatever state you put in here is where the agreement is going to populate. Okay, so if I send an agreement now, so say I'm on the phone with the client and it's a lead, I've entered it as a lead, and I'm talking to them on the phone, they want me to send them agreement, so I just pop in here, hit send agreement, and as you can see, it comes up, the consumer credit file rights come up first. The other thing that we've done here inside of Credit Butterfly is that we have integrated with Signwell as well. So again, you have signatures. This is all comes with Credit Butterfly. You don't pay any extra for any of this. So you get the agreement. Once you hit send agreement, it will send it directly to the client, and all of the signatures happen the way they should. So this is very CROA compliant. So you see how it's like Mickey Mouse, it puts everything in there. Okay, and then it also has, they fill out their basic information, which will be important. I'm going to show you what this flow does. So if we sent the agreement, once we send the agreement, I think it's got a little lag because we're on Zoom. Once you send the agreement here, it will automatically turn it into a prospect. So it automatically turns that lead straight into a prospect. It will send the signature or the agreement directly to your client for signature. Once your client goes in and signs the agreement, it will automatically switch this to a prospect or to a client, and everything will already be in there. Okay, so it will automatically populate the name, social, date of birth, everything. So there's no data input for you at all. Once you do that, then you just import the credit report here. And the other really cool thing that Credit Butterfly does is it creates step-by-step action plans for every client. So here's one that comes, here's the credit scores. It'll show you the utilization ratio and what the target is, how much they should pay to hit that target. And this again will also go into the client's portal and populate. The other cool thing is this person only has one secured or one credit card. So they're going to need a secured credit card based on their credit scores. And all of your credit card offers are populated in here. So there's 3 offers. And this is, again, we have another integration here with Credit Card Broker. So you will be able to go in through your settings, and I'll show you how the settings work. So for like your portal settings, you would add your own Credit Card Broker affiliate ID in here. So all of those offers would be yours. So you're obviously getting the affiliate payouts for those. For the state agreements, this is how they work. So you would select your state or which states that you are bonded in or what have you. Some, again, you don't need to be bonded in and things like that. But you would add in, what is your total fee for the life of your agreement? What is the name of your bond company, your bond account number? All of this populates into the agreement. So whatever state it is, you would just put it in. Now, John has, if anybody signs up today, we have a special offer for our beta program for Credit Butterfly today. If anybody would like to use Credit Butterfly, John has very nicely offered to do a $100 consultation today, and we're giving you free onboarding where he will write your service scope. for you, which is here, because everybody's service scope is going to be a little bit different. Okay, the way that you write it, but he'll make sure it's compliant to make sure that you're, you know, charging your fees in a compliant manner with the right waiting period, like, you know, to be paid within 3 days. You can see how, and he'll write that all for you. Anyways, I just wanted to give you guys a quick little view of that. Do you guys have any questions?
That was Gary that asked that question.
Okay, and hey, Tim, I see your message here, but what's the ACR? Just, I'm gonna call you. I'm gonna take a photo.
Annual credit report.
Oh yeah, I mean,